We got about 1 minute according to this clock.
Sounds good.
All right, I'm showing 9 o'clock. Are you guys ready to go?
Yes,
Rock and
Chairman.
roll.
All right, great. Good morning, everyone. This meeting is called to order. Mr. Trobman, has anyone signed up for public comment?
Good morning. We don't have anyone registered for public comment this morning.
All right, thank you very much. Good morning, Ms. Miller.
Good morning, sir.
Here you are. On agenda item 3, I'm showing we have no cases to reconsider. Is that correct?
That's correct. No cases.
Okay, so we'll consider tax liability cases on agenda item 4, and I think we have 2 tax cases on docket 28.
Yes, sir, that is correct. The first case is TD-19-135-0919. Commissioner Demerson?
I agree in part and disagree in part with the staff recommendation. I agree that the decision will ultimately need clarification as to what should happen after a finding is made that each entity is a non-experienced rated employer. However, I believe that we need more information on the specific nature of each successor for all 4 of the acquisitions that occurred in this case. Accordingly, I would grant the MR to clarify the prior ruling and to obtain additional evidence regarding the specific identities of the successor in each acquisition.
Commissioner Alvarez?
I agree with staff's recommendation.
And Mr. Chairman?
Agree with staff recommendation.
Thank you.
Chairman, let me short form dissent on that. If staff, yeah, let me short form dissent on that one.
Yes, sir. Short form dissent.
Thank you.
Moving on to the second case, it's case number TD-20-077-0620. Commissioner Demerson?
I agree with staff recommendation.
Commissioner Alvarez?
I agree with staff's recommendation.
And Mr. Chairman?
My vote is to hold pending a memo from OGC on whether following franchise requirements should require the transfer of compensation experience.
Here, I'm fine with that.
All right. I have a majority vote to hold pending OGC memo, and we will resubmit the case. And that's all the tax cases for docket 28.
Thank you very much. We have no fair housing cases on agenda item 5. Is that correct?
That's correct. No cases.
We'll move to agenda item 6. We have no wage claim cases pulled for additional discussion on docket 28.
That's correct. None pulled, but you should have received the short form dissent list this morning.
I move we accept staff recommendations on the remaining wage claim cases on docket 28.
I second the motion except for those cases on which I am dissenting as reflected on the wage claim short form dissent list for docket 28.
And I concur with the chairman's motion except for the cases on which I am dissenting as reflected in the wage claim short form dissent list for docket 28.
Motion passes with the exceptions noted.
Thank you.
Let's move to agenda item 7, consideration of unemployment insurance cases on docket 28. Please proceed when you're ready.
Yes, sir.
Case number 2421254. Commissioner Alvarez?
The claimant's appeal should be deemed timely. The decision mailed to the claimant on August 5th, 2019 was returned to the commission on August 12th, 2019. Since the claimant did not receive the decision, her appeal should be deemed timely and resubmitted for merits. Deem the claimant's appeal timely and resubmit.
Although we have proof that the claimant did not receive the AT decision, the claimant waited almost 9 months after hearing before filing an appeal. Because the claimant should have known that an AT decision was to be sent to the parties after the hearing, and he sat idly by for so many months without taking any action on his claim, the claimant appeal is not timely, and we do not have jurisdiction to consider the underlying merits. Therefore, dismiss the claimant's appeal as late and leave the underlying AT decision in full force and effect.
I would concur with Commissioner Alvarez.
Thank you. Majority vote is a timely CA appeal. We will resubmit. Next case.
Case number 2474103. Commissioner Alvarez?
The case should be reheard. The claimant was laid off and the employer has never contested the claimant's receipt for benefits. The claimant is currently disqualified for his entire benefit year because it was determined that he received severance. In the claimant's commission appeal, the claimant's attorney provided additional information that the payments the claimant received were given in exchange for the claimant signing a release for an age discrimination and FMLA claims he had against the employer. If shown to be true, this information could change the outcome of the case. As such, the case should be reheard to enter a copy of the agreement into the record and obtain additional information about any claims the claimant had.
The AT decision should be modified. I agree that the employer should be made a party of interest to this claim. Regarding the underlying issue, the severance pay was disqualifying because it was not negotiated. It was not based on an alleged violation of the Civil Rights Act of 1991, and it was not pursuant to a claim or cause of action filed in connection with the employment relationship. Therefore, none of the exceptions to disqualification under Section 207.049B of the Act apply to this case. In addition, the claimant stated several times that the lump sum payment constituted 82 weeks' pay, which was based upon a predetermined formula involving his years of service with the company. Thus, the evidence does not support that the claimant should be disqualified only for the week in which he received the payment. However, the AT decision should be modified to begin the disqualification effective November 17, 2019, the beginning date of the claim week in which the claimant received payment. Based on this evidence, we should modify the AT decision. The claimant received disqualifying severance pay from November 17, 2019 through October 31st, 2020. Recalculate overpayment and make the employer a party of interest.
I would agree to rehear the case.
Thank you. We'll rehear the case and resubmit.
Next case is 2477578, Commissioner Demerson.
The commission should rehear this case because the AT decision is not supportable based on the current record. The employer is in the home health care referral industry. PRN employees, such as the claimant in this case, are necessary and an unavoidable component of that industry. In fact, this unique need for PRN employees was the impetus for TWC's creation and adoption of the home health care precedent. As such, the home health precedent should supersede the claimant's PRN status, and the question as to which party severed the employment relationship in this case is still at issue. We know that the claimant last worked for his employer on August 15, 2019. We also know that the claimant was offered other assignments after that date. What we don't know is the first date the claimant was offered a new assignment after her previous one ended on August 15, 2019. If the claimant rejected an offer shortly after that date, then this case would be analyzed as a voluntary resignation and the employer should not be charged. Accordingly, before we render a decision, we should rehear this case to determine the next date the claimant was offered work after August 15, 2019, and why the claimant rejected that offer.
The decision should be affirmed. The claimant was working on call as needed and was therefore separated due to a lack of work at the end of each assignment. Despite the administrator's testimony that the claimant continues to be employed with the employer, they have not provided work in almost a year. Because the claimant's separation from employment was non-disqualifying, the employer's account is subject to charge. Affirm the AT chargeback.
Reverse the AT, no chargeback.
Short form dissent.
All right, we have not received a majority vote as of yet. Commissioner Demerson's vote was to rehear the case. Commissioner
I would
Demerson?
agree with the chairman.
Thank you. Majority vote is that the employer will not be charged. And Commissioner Alvarez, I have your short form dissent.
Yes.
Thank you, sir.
Next case is 2483634, Commissioner Alvarez.
The AT decision on the timeliness of the claimant's petition to reopen should be affirmed. The claimant was in quarantine because he was likely ill from COVID-19. As a result, he was unable to check his designated mailing address at his parents' home because of the risk of exposing them to the deadly disease. Given the state of emergency caused by COVID-19, the AT decision in this case was not effectively delivered to him, and his petition to reopen should be deemed timely. affirm the AT timely petition to reopen and resubmit the case on the merits.
We should modify the appeal tribunal decision. The claimant uses parents' residence as his address of record for claim purposes because of mail reliability at their address. Despite this, the claimant did not check to see if they had received any of his claim correspondence for about a month, nor did he contact TWC to check on the status of his claim. As the appellant, the claimant was responsible for ensuring he was informed of important dates and deadlines. In addition, although the claimant may have been ill during part of the appeal period, there is no good cause exception to the timeliness rules. It is a standard practice for the commission to dismiss late appeals from both parties based on good cause reasons such as illness or hospitalization during the appeal period. Thus, because the claimant appeal is not timely and there is no good cause exception to the timeliness rules, we should modify the AT decision. The claimant filed a late Rule 16 petition to reopen, misconduct, void chargeback ruling, availability not eligible, December 29th, 2019 through January 4th, 2020.
Modify the AT, late petition to reopen, misconduct, void chargeback, claimant not available for December 29, 2019 through January 4, 2020.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez.
Next case, 248570, Commissioner Alvarez.
The AT decision in this case is not supportable. On the separation issue, I agree with the AT that the claimant had good cause for missing the AT1 hearing. On the separation, the claimant quit the job because the employer refused his request for a reasonable medical accommodation. The claimant requested to work in a branch office that was closer to his home because of his severe sleep apnea. The claimant's medical condition made long commutes dangerous, and his doctor recommended that the claimant have a shorter commute to work. The employer denied the claimant's request, and the claimant stopped working or earning wages as a result. The claimant quit due to a medically verified illness and should not be disqualified. Modify the AT. Claimant had good cause for their non-appearance at AT1, no voluntary leaving, no chargeback due to MVI.
The AT decision should be affirmed. I do not dispute the good cause finding. As to the job separation, the claimant's failure to obtain the known and necessary certification is the equivalent of work-connected misconduct per commission precedent. We should therefore affirm the AT decision. The claimant had good cause for his non-appearance, misconduct, no chargeback.
Affirm the AT, claimant established good cause for AT1, misconduct, no chargeback.
Commissioner Alvarez, do you have a dissent?
Yes, ma'am. Short form dissent.
Thank you, sir.
Next case, 248723, Commissioner Demerson.
The AT decision should be affirmed. The employer testified that the claimant was required to consult with the Capital Improvement Program, the CIP, manager when making a purchase under the sole source exception to the employer's procurement procedures. The claimant began to comply with the procedure after being told to do so by the city engineer. Nevertheless, the claimant admitted that he did not consult with the CIP manager as required because the vendor he was dealing with was the sole source of a piece of equipment. The city manager had told the claimant he needed to follow the city engineer's instructions, and there is no indication that the claimant had permission to ignore the employer's instructions in this case. In addition, the claimant had been warned previously about not following the employer's rules. As such, the claimant's failure to follow instructions constituted work-connected misconduct, and we should affirm the AT decision. Misconduct, reimburse an employer not billed.
The decision is not supportable. The employer or governmental entity alleges that the claimant failed to follow a procurement policy. Such policies are typically detailed and in writing. A final ruling should not be issued until the written policy is admitted into evidence and facts are developed to determine if the written policy was followed. I would ask for rehearing.
Affirm the AT, misconduct, reimbursing employer not billed.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez.
Next case, 2491335, Commissioner Alvarez.
The claimant's ineligibility was purportedly naming the incorrect last work on the continued claim dated December 7, 2019, but entered into the system by staff on January 29, 2020. It states that the claimant worked from December 4, 2019 through December 5, 2019 for 0 hours, earning no wages. The claimant denied he informed staff that he worked for the employer on a continued claim. Fact-finding statement shows staff was unable to contact the claimant on January 29, 2020. The claim certification for the week in question states that the claimant did not work. The employer testified the claimant did not work during the period. There is no evidence that the claimant had a separation during this time, and the claim has since been voided. The incorrect last work ineligibility and resulting overpayment should be voided. Regarding the requested memo, it is unnecessary. The claimant did not have a separation, and the continued claim has been voided. The separation from the newly proposed employer has already been listed on an additional claim. Void the last work and overpayment determinations.
In view of additional evidence concerning the work separation that may not have been considered at the earlier levels of the claim and appeals process, I support the staff recommendation that we hold the case pending the results of a memo to UIO and CS concerning the correct last employing unit for the claimant's continued claim.
Hold pending LEU investigation.
Thank you. We will hold and resubmit the case following an LEU investigation by UIO and CS.
Alrighty, next case, 2492000, Commissioner Demerson.
The appeal tribunal decision should be affirmed. The claimant was discharged for her rude workplace behavior. A first-hand witness testified that during the final incident, the claimant treated her in such a way as to make her feel like she was back in prison. File documents also contain more information describing how the other employees felt bullied and intimidated by the claimant. In addition, the executive director testified that he handed a copy of an upcoming charge to the claimant's job in July of 2019. These changes, according to file documents, came as a result of a grievance filed against the claimant. As the preponderance of evidence established that the claimant mismanaged her position of employment, we should affirm the AT decision. Misconduct, reimbursing employer not billed.
The decision should be reversed. The employer alleges that the claimant was rude to her subordinate employee. The employer alleged the claimant had a tone and would roll her eyes. Both parties, however, testified that most of the communication was by text. The texts are in evidence, and there is nothing objectionable in them. The employer's credibility was further called into question when the executive director testified that he was a witness to some incidents before finally admitting that he had witnessed no such incident because he did not work at the same location. The claimant has consistently and credibly denied any allegations. The evidence is insufficient to establish misconduct. Reverse the AT, no misconduct, chargeback.
Reverse the AT, no misconduct, bill reimbursing employer.
Short form.
All right, I have a short form dissent for Commissioner Demerson. And just to clarify, Commissioner Alvarez, reimbursing employer will be billed. You stated chargeback, but I just wanted to confirm you meant that they would be billed?
At this point, let's say yes.
Very well. We
Yes.
have a
Yes,
thank you, sir.
thank you.
Majority vote with the Demerson short form dissent.
Thank you.
Next case, 2496400, Commissioner Alvarez.
The decision should be reversed. The claimant worked for the employer for less than 3 months. Despite working to the best of her ability, taking multiple trainings, and asking for assistance, the claimant was never able to perform to the employer's standard. In accordance with appeal number 1456-CA-77 and appeal number 1123-CA-76, the claimant's inability to perform to the employer's standard cannot be deemed misconduct. The claimant worked in a law office and her duties included filing, obtaining documents, checking court announcements, fielding calls, and translating. These duties are not simple in nature. Reverse the AT, no misconduct.
The AT decision should be affirmed. The claimant failed to correct her work and complete simple tasks after prior warnings and after she was granted deadline extensions. The claimant mismanaged her position of employment, and we should affirm the AT decision of misconduct.
Affirm the AT misconduct.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez.
Next case, 2497654, Commissioner Alvarez.
The decision should be reversed. The only issue in this case is whether the claimant was registered to work. The claimant has submitted evidence that he was and is registered for work in Florida, his state of residence. There is no evidence this information was ever requested from the claimant, and he provided it to an agency immediately after receiving the determination. The claimant was registered for work in his state of residence throughout the relevant period and should not be ineligible. Reverse the AT, no registration ineligibility.
The AT decision should be affirmed. It was the claimant's obligation to notify TWC that he was registered for work in Florida. Since the claimant failed to provide sufficient evidence of his registration until March 12, 2020, we should affirm the AT decision. Registration ineligible from February 23rd, 2020 through March 14, 2020.
Reverse the AT, registration eligible.
Be short form.
Thank you. I have a short form dissent for Commissioner Demerson.
Thank you.
Next case, 2509255, Commissioner Demerson.
We should affirm the appeal tribunal decision. The claimant worked 1 day for a temporary help firm and quit when she failed to report back for reassignment, despite being aware of this requirement. Since the claimant quit because she wanted to seek different work and failed to report back for reassignment, her quitting was without good cause connected with the work. Although the claimant only worked for 1 day, Section 207.045G-1 of the Act does not apply. The first requirement that must be met in order for this section of the statute to apply is that at the time the work began, the individual was receiving benefits under this subtitle. Because of a prior claim disqualification, the claimant was not receiving benefits when she began to work in this current case. Not only was the claimant disqualified from the receipt of benefits, she had also not worked enough to requalify for benefits. Thus, since the claimant did not meet the first of several criteria required by statute, application of 207.045G-1 is not proper. We should affirm the AT decision, voluntary leaving.
The claimant was discharged. The claimant worked a single day for the employer on a 1-day assignment. The claimant was paid only $9 per hour. The claimant's maximum wage demand was $14.40 per hour. In the absence of evidence that the employer could offer, the claimant worked that paid close to the claimant's maximum wage demand. The work was not suitable for the claimant. Reverse the AT, no voluntary leaving.
Reverse the AT, no voluntary leaving.
Let me a long form dissent on this one.
Thank you. Commissioner Demerson, I have a long form dissent for you.
Yes, thank you.
Next case, 2515043, Commissioner Alvarez.
The AT decision should be affirmed. The claimant originally worked full-time until 2/7/20, but moved to a part-time as needed position thereafter. The claimant's full-time position was filled by another employee. The claimant then worked as needed until she filed the IC. The claimant last worked from 3/5/20 to 3/6/20 and did not work thereafter because there was no work available. She was involuntarily separated for a non-disqualifying reasons. Affirm the AT, claimant filed a valid claim, no misconduct chargeback.
The AT decision should be modified. I agree that the claimant filed a valid claim. Regarding the job separation, the claimant quit and changed her status to PRN because she was moving. Consequently, any periods of unemployment due to the claimant's PRN status are attributable to the claimant. Furthermore, the evidence is insufficient to show that the claimant was separated due to the disaster. Since the claimant was responsible for her PRN status, and since she quit for personal reasons, we should modify the AT decision. The claimant filed a valid claim, voluntary leaving, no chargeback, adequate employer response.
Modify the AT, valid claim, voluntary leaving, no chargeback.
Short form dissent.
All right. Mr. Chairman, did you want to add an adequate response ruling there because of the claimant's disqualification?
Adequate employer response.
Thank you, sir. And Commissioner Alvarez, I have a short form dissent.
Yes, ma'am.
Thank you.
Next case, 2517752, Commissioner Demerson.
We should grant a rehearing in this case. First, I do not dispute the timeliness finding. As to the job separation, two of the company's owners were out of town at a funeral and were unavailable to participate and provide testimony at the hearing. Because testimony from these witnesses is clearly relevant and should be considered before we render our decision, we should rehear this case for testimony from these firsthand witnesses.
The decision should be affirmed. The claimant provided sworn testimony that he filed an earlier appeal, and he provided a copy of the earlier appeal with his record appeal. Consistent with appeal number 95-014321-50-10245595, the claimant's testimony corroborated by a copy of his earlier appeal is sufficient to establish that he filed an earlier appeal. With regard to the job separation, the claimant was the only party providing firsthand testimony. The claimant and the employer discussed the claimant retiring at some point, but the claimant did not provide a date for his retirement. The claimant was discharged at the employer's convenience after the employer hired the claimant's replacement, and he spent a year training him. Affirm the AT, timely appeal, claimant appeal, no misconduct, chargeback.
Affirm the AT, timely claimant appeal, no misconduct, chargeback.
A short form.
Thank you. I have a short form dissent for Commissioner Demerson.
Thank you.
Next case, 2518249, Commissioner Alvarez.
The AT decision should be reversed. After the employer arranged for a St. Patrick's Day potluck meal, the claimant requested a Black History Month potluck. Rather than approve her request, the claimant's supervisor sent the issue to HR for approval. The employer claimed that HR had approved of the claimant's idea. However, rather than just explicitly notifying her supervisor of the potluck approval, HR arranged for meetings with the claimant to address the conflict between the claimant and the supervisor. The claimant became upset during these meetings and briefly left the room where they took place. By the employer's own admission, the decision was then made to discharge the claimant because her supervisor did not feel comfortable working with her. The claimant was never warned that her attitude was jeopardizing her job, and she never refused to follow any instructions. The claimant's actions did not rise to the level of misconduct connected with the work. Reverse the AT, no misconduct, chargeback, void adequate response ruling.
The AT decision should be modified. The claimant's unprofessional conduct in 2 consecutive meetings while on final warnings constituted mismanagement of her position of employment. We should modify the AT decision. Misconduct, no chargeback, sever, adequate response.
Modify the AT, misconduct, no chargeback, sever, adequate response.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez.
Next case, 2521948, Commissioner Demerson.
The appeal tribunal decision is fully supportable and should be affirmed. The claimant initiated the job separation when she did not return to work after her FMLA leave had expired. The illness of the claimant's mother was a very compelling reason for not returning to work as scheduled, but it was personal and not related to the work. Thus, it did not constitute good cause connected with the work for quitting, and we should affirm the AT decision, voluntary leaving, no chargeback.
The claimant had been off from work on approved FMLA when it ended. The claimant sought an extension, which was denied. The claimant had been in the hospital tending to her mother and was unable to leave due to quarantine restrictions. On April 6, 2020, the claimant's mother was moved to an ICU and the claimant was allowed to return home to begin a 14-day quarantine. The employer discharged the claimant the next day for accumulating too many attendance points. The employer's determination documents only show the claimant accumulated 6 points, which was insufficient for discharge under the employer's policy. Additionally, the employer's progressive disciplinary plan required a warning and a PIP for occurrences in a rolling 6-month period before termination. The claimant had not received any disciplinary action since 2018. The employer failed to comply with their attendance policy and failed to establish the claimant committed misconduct connected with the work. Reverse the 18, no misconduct chargeback.
Modify the AT, no voluntary leaving, no chargeback, urgent and compelling.
All right, we have not achieved a majority vote. We do have the claimant qualified for benefits with Chairman Daniel and Commissioner Alvarez, but the rationale for qualifying is different.
Ms. Miller, I would agree with the chairman's ruling.
All right, and then on the chargeback ruling, we have a majority vote with Commissioner Demerson and the chairman. So we do have a majority vote. Claimant is not disqualified, left work with good cause. No chargeback to the employer. Does anyone wish to have any comment or objection on any of the rulings in the case?
Ms. Miller, can I ask again what the chairman's decision was on this case?
I'm sorry, could you repeat that?
Can I ask what the chairman's decision was on this case?
He voted VLOO, CBOO, urgent and compelling.
I would agree with the chair.
We have majority vote for VLOO, CBOO, urgent and compelling. Commissioner Demerson, any objections?
Short form dissent.
Short form dissent for Commissioner Demerson. Thank you, sir.
Thank you.
Next case, 2522262, Commissioner Demerson.
We should reverse the appeal tribunal decision. The claimant was fired for failing a random drug test. While it is true that the employer did not initially submit documentation that the drug test was confirmed using the GC/MS method, our drug testing precedent requires employers to present all 5 factors in order to overcome a claimant's sworn denial of drug use. Here, the claimant did not appear to deny any drug use under oath, nor did he deny drug use in his fact-finding statements. Therefore, because the preponderance of the evidence established that the claimant failed a drug test in violation of the employer's zero-tolerance drug-free workplace policy, the claimant was discharged for misconduct connected with the work. We should reverse the AT decision, misconduct, no chargeback, adequate employer response.
The decision should be affirmed. In accordance with long-standing precedent, an employer must present documentation to establish the initial test confirmation method. The employer failed to provide such documentation despite the opportunity to do so. As such, the employer has failed to establish the claimant's test results constitute misconduct. Furthermore, there is a broken chain of custody, as the test was never signed by the receiving lab. I would not agree to a rehearing in this case. The employer had an opportunity to gather this information before the hearing and failed to do so. Additionally, the information the employer wishes to provide only generally states the facility's normal confirmation procedures and falls short of the required documentation for the claimant's specific test. Affirm the AT, no misconduct, chargeback.
Vote to rehear the case to bring all the necessary evidence into the record.
We have not yet achieved a majority vote.
I'm fine with rehearing, Ms. Miller.
Thank you. We have a majority vote to rehear the case. Next case,
Next
please.
case, 2522596, Commissioner Demerson.
We should reverse the appeal tribunal decision. Prior to the claimant filing her claim in March 2020, the employer offered the claimant several assignments that the refused to accept. The employer's actions indicated that the employment relationship has not yet ended. The job separation did not occur when the claimant left her last assignment, as the AT concluded. Rather, under the home health care precedent, it occurred when the claimant rejected multiple assignments for personal reasons, such as her school schedule. Since the claimant initiated the job separation and she did not establish that she had good cause to reject the work she was offered, we should reverse the AT decision, voluntary leaving, no chargeback, adequate employer response.
The decision should be affirmed. The claimant worked in a home health care referral industry in accordance with longstanding commission precedent. For either the worker or the referral service may initiate reassignment without a resulting separation. Thus, the claimant was not separated when she requested removal from the client. Instead, the working relationship continued until one party clearly notified the other that the relationship had ended. Here, the employer was the first party to notify the other that the relationship had ended when they notified the claimant on July 1st, 2019, that there was no further work available. The claimant was laid off at that time. Furthermore, the employer did not have any more work to offer the claimant until July 30th of 2019. A claimant cannot be expected to remain in an indefinite employment relationship when the employer is unable to offer work for a full month. Affirm the AT, no misconduct chargeback.
Affirm the AT, no misconduct chargeback.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Demerson.
Thank you.
Next case, 2526619, Commissioner Demerson.
We should modify the appeal tribunal decision. Section 207.046A3 of the Act states that an individual will not be disqualified if he or she leaves the workplace to care for the individual's terminally ill spouse. However, the statute very clearly requires a physician's statement or other medical documentation to support the terminal illness findings. Here, no medical documentation was provided. I do not doubt that the claimant's spouse was ill and that she had a very compelling personal reason for leaving her job when she did. However, because she did not allege that her spouse was terminally ill, nor did she provide the required documentation, we should modify the AT decision, voluntary leaving, void the chargeback ruling. In the alternative, I would agree to rehear this case to provide the claimant the opportunity to submit the medical documentation required by the statute.
I would agree to rehear.
Rehear.
Thank you. We will rehear the case and resubmit.
Next case, 2526927, Commissioner Demerson.
We should modify the appeal tribunal decision. After experiencing a traumatic incident at work, the record indicates that the claimant stopped working at the advice of her doctor due to complications related to her pregnancy. Thus, it should be qualified benefits and the employer's account should be protected from charge under 207.045D. Accordingly, we should modify the AT decision. No voluntary leaving, no chargeback, separation caused by the claimant's medically verified illness or pregnancy.
I would agree with the Commissioner Demerson, modify no voluntary leaving, no chargeback due to MVI.
Agreed.
Thank you. We have a unanimous decision.
Next case, 2527963, Commissioner Alvarez.
The AT decision should be reversed. The claimant's own supervisor testified in the AT hearing on the employer's behalf. The supervisor characterized the claimant as a hard worker who always made his sales calls, I should say. The supervisor also stated that the customers were just not saying yes to the claimant. He also admitted that the other sales employees in the company were placed on performance warnings, leading to the conclusion that the employer was simply under financial pressure to reduce its sales force. Based on the credibility testimony from the claimant's supervisor and the claimant's unsatisfactory performance did not constitute misconduct because the claimant was working to the best of his ability. Reverse the AT, no misconduct chargeback.
The AT decision should be affirmed. The claimant knew that he would be discharged if he failed to meet the sales goal for the month. The claimant had consistently met sales goals in the past, and his job duties and responsibilities had not changed. Based on this evidence, since the claimant was capable of meeting the employer's expectations, we should affirm the AT decision. Misconduct, no chargeback.
Reverse the AT, no misconduct, chargeback.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Demerson.
Next case, 2532658, Commissioner Alvarez.
During the month of April, the agency online portal had numerous issues due to the number of people trying to access the portal. These issues even prevented staff from being able to access the portal at times and made it difficult or impossible for parties to access their determinations and file appeals. The agency has publicly admitted these issues and told parties that it would not be held against them. However, in this case, we are holding the claimants responsible for the agency's failures. Therefore, as the claimant was not at fault for his late appeal, we should deem the claimant's appeal timely and resubmit the case for merits.
Based on the information in the record, we should deem the claimant's appeal as timely and resubmit this case.
Can you read back to me the two commissioners' votes, please?
Yes, sir. They both voted to deem the appeal timely and resubmit the case.
Okay, I concur.
Thank you. We have a majority vote. It is unanimous.
And the final case is 2534839, Commissioner Alvarez.
The AT decision should be modified. The claimant was discharged because he made mistakes in the installation of a countertop. The claimant was aware of the correct installation procedures, but he was confused and disoriented as a result of his extreme high blood pressure and the medication he took for this condition. The claimant's separation was caused by a medically verified health condition and was not the result of the claimant's misconduct. Modify the AT, no misconduct, no chargeback due to MBI.
The AT decision should be affirmed. The claimant repeatedly failed to follow the employer's installation procedures despite following the procedures successfully in the past. Additionally, the employer took reasonable measures to ensure that the claimant could perform his job safely. After that, it was incumbent upon the claimant to notify the employer if he was not feeling well enough to do the job. Since the claimant did not take adequate steps to prevent the final incident from occurring, I would not agree to an MVI, and we should affirm the AT decision. Misconduct, no chargeback.
Affirm the AT, misconduct, no chargeback.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez, and that is the last UI case pulled for additional discussion on docket 28. You should have received the short form dissent list this morning.
Move we accept staff recommendations on the remaining UI cases on docket 28.
Chairman, I second the motion except for those cases on which I am dissenting as reflected on the UI short form dissent list for docket 28.
I concur with the chairman's motion except for the cases on dissenting as reflected in the UI short form dissent list for docket 28.
The motion passes with the exceptions noted.
Thank you very much.
Thank you. This brings us to the end of agenda items 3 through 7. Let's pause for briefly to reset for the rest of the meeting.
Thank you.
I meant to the full yesterday, we were talking about, I know everybody said, told you that happy belated birthday, and,
All right. Let's get started back here with agenda item 8, discussion, consideration, and possible action regarding publication for public comment of proposed rules relating to federal extended unemployment compensation rules pertaining to the Emergency Employment Insurance Stabilization and Access Act of 2020 and the Coronavirus Aid, Relief, and Economic Security Act.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Jimerson, and Mr. Cerna. For the record, I'm Jason Stolinsky, RID Policy Planning and Prosecutions. Before you today is a proposal to amend the Chapter 815 Unemployment Insurance Rules to address the Emergency Unemployment Insurance Stabilization and Access Act of 2020, also known as UISA, and the Coronavirus Aid, Relief, and Economic Security Act, otherwise known as the CARES Act. Previously, the Commission undertook emergency rulemaking to address this legislation. The emergency rules addressed areas including waiver of overpayments, program coordination, employer notification, and extended benefits. These rules continue to be necessary to effectuate this legislation, but require the formal rulemaking process to become permanent. The proposed rules before you aim to make the emergency rules permanent with a few minor modifications to make them more generally applicable and easier to understand. This proposal also creates a new subchapter G in Chapter 815, as well as providing for additional regulations to cover the subject areas of appeals, overpayments, and fraud under the CARES Act. Today, staff is seeking your direction on submitting these proposed rules to the Texas Register for a 30-day public comment period. If so directed, staff seeks approval to make any minor non-substantive corrections to the document for purposes of publication in the Register. With that, I'm available for any questions you may have.
Thank you. Comments or questions?
No questions, comments.
None here.
Do we have any motions?
Chairman, I move that we publish the proposed rules relating to Chapter 815 to the Texas Register as discussed.
Second.
It's been moved and seconded, and we're unanimous. Thank you.
Thank you.
Let's move to agenda item 9. TRS 4-year review and Chapter 809 amendments, discussion, consideration, and possible action regarding Texas Rising Star 4-year review and policy concept amendments, Chapter 809, 40 Tech, Chapter 809, regarding the Texas Rising Star program.
Morning, can you hear me?
And
Okay. Good morning, Chairman, Commissioners, Mr. Cerna. For the record, Allison Wilson, Child Care and Early Learning Division. This policy concept is the result of a year-long process to review the Texas Rising Star program and develop a set of recommendations for improvement. These recommendations reflect the collaborative work of a dedicated group of stakeholders, as well as public input from across the state. This policy concept includes a set of multiple issues for your consideration today. The first issue is related to the Workforce Registry. TWC has been supporting the use of the Workforce Registry for several years now. The data in the system helps TRS assessors more efficiently validate staff qualifications. Staff seeks direction on amending minimum eligibility requirements defined in 809.131 to require Texas Rising Star programs and applicants to create staff accounts within the Workforce Registry. Issue 2 regards adding an entry level to the Texas Rising Star program and establishing goals to achieve higher levels of quality. This issue is one that generated a lot of interest. It would create an entry level into Texas Rising Star. The work group discussed this as an opportunity to expand awareness of TRS, provide an on-ramp for providers that may not have considered TRS, and increase accountability for subsidy dollars. There has been some discussion on what to call this new entry level, perhaps 1-star or pre-star level. And we believe that we will get feedback on the naming during the policy concept comment period. Staff seeks direction on amending Chapter 809 to create an entry-level designation and defining the eligibility criteria, and developing a plan that lays out strategic goals and an incremental rollout to move all subsidy providers into TRS, and including long-term goals to increase the quality ratings for all programs. Issue 3 relates to the impact of certain deficiencies, childcare licensing deficiencies on Texas Rising Star certification. These changes shift the focus to the deficiencies that most directly relate to the quality of care children receive. They allow providers an opportunity to fix issues without impacting their financial ability to continue to provide quality services, and increase mentoring and technical assistance support for providers with deficiencies. Staff seeks direction on amending 809.132 to change the consequences of certain childcare licensing deficiencies for certified TRS programs and applicants as described in attachments 2 and 3. and ensuring that customers have access to information about each program status with Texas Rising Star. Issue number 4 relates to a continuous quality improvement framework. In order to promote continuous quality improvement within TRS, the work group recommended a CQIP framework to help provide targeted and structured technical assistance and customized coaching to set specific improvement goals. Staff seeks direction on amending 809.133 and revising the TRS guidelines to require all applicants and programs to participate in a CQIP as described in the policy concept, and determining an optimal number of TRS mentors with consideration given to the more robust CQIP framework and providing the Commission with recommendations on funding needed to support this effort. Issue number 5, new training and certification requirements for Texas Rising Star staff. TWC previously funded and developed a TRS assessor certification to ensure that these TRS staff demonstrated a level of proficiency needed to serve as an assessor. Along these same lines, this recommendation would establish a micro-credential framework. As we seek to focus on improving the quality of TRS providers, we want to ensure that mentors possess the skills and aptitudes needed to improve the quality of mentoring. Both mentors and assessors would be supported with ongoing professional development and evidence-based peer learning communities. And this is further explained in attachment 1 on page 12. Standardizing, training, and certifying staff helps ensure that TRS certification process, that the process is reliable and credible across the state. Staff seeks direction on the following. Mentor and assessor roles and responsibilities would be amended in 809.134 to define the separate roles and responsibilities as noted in the policy concept. We're also seeking direction on amending 809.134 to establish minimum training requirements for mentors and assessors, also as described in the policy concept, and bringing back statewide initiatives for your consideration as described in the paper to support these changes. Issue number 6, streamlining and reweighting categories for Texas Rising Star measures. The TRS work group made several recommendations regarding streamlining and reweighting TRS measures as outlined in the policy concept. Staff seeks direction on amending 809.130 to align measures with the 4 categories proposed by the work group. Weighting category 2, which is teacher-child interactions, at 40% and all remaining categories at 20%. Issue number 7 relates to revisions to various TRS measures and processes. The work group also made recommendations regarding the processes by which provider assessments are scheduled, as well as how assessments are conducted for providers that are also nationally accredited. Those are outlined in the policy concept as well. Staff seeks direction on approving the revised TRS guidelines and bringing forward a subsequent statewide initiative for your consideration to make the recommended automation changes as noted in the policy concept. Issue number 8, a statewide campaign for Texas Rising Star outreach and education. The work group recommended that TWC consider efforts to better educate families on TRS and high quality childcare. It also recommended that TWC develop an outreach plan to emphasize family and consumer education around choosing high quality programs and encouraging and informing programs to remain or become high quality. Staff seeks direction on developing a cost estimate for a statewide outreach campaign to educate families on Texas Rising Star and high quality childcare. Issue number 9 is our timeline for implementation. The proposed timeline provides time for Texas Rising Star staff as well as early learning programs to become familiar with the revisions and implement program changes. Staff seeks direction on the proposed timeline for implementation of the revisions to TRS. And then lastly, we have an informational item. This is related to the proposed centralization of TRS the Texas Rising Star assessment function. In 2018 and 19, TWC funded the Strengthening Texas Rising Star Implementation Study, which examined measure validity and rater reliability. Assessor inter-rater reliability has significant implications for the fairness and accuracy of quality ratings. Based on the study's results, the work group recommended that TWC consider pursuing the consolidation of the Texas Rising Star assessment function. Centralizing the assessment function will help to ensure alignment and consistency in ratings across the state. This will require a legislative change. We would like to bring this back to the Commission for consideration as part of the Commission's priorities for the 87th Texas legislative session. And that concludes my remarks, and I'm happy to answer any questions you have.
Comments or questions?
No, sir.
Hi, Chairman, I'd like to just thank Reagan and Allison for seeking the input of those stakeholders and those public input. That appreciate that big time. And then on issue number 8, I just want to make sure that as we look into statewide applications, that we don't forget those rural communities. And it says statewide, and I know we're going to do it statewide, but I want to make sure that I emphasize the fact that the rural communities are out there as well. But thank you for the work. This is good issues.
Do we have a motion?
Chairman, I move that we approve the policy concept for the amendments to Chapter 809 Texas Rising Star Program as discussed by staff.
I second that motion.
Been moved and seconded. We're unanimous. Thank you. Staff does not have anything to present under agenda item 10, statewide initiatives. So we'll move to agenda item 11. Discussion, consideration, and possible action regarding guidance on resource utilization and implementation of services and strategies to target disaster relief efforts and public health emergencies, including those funded with the Department of Labor's Disaster Dislocated Worker Grant.
We have 2 items. The first presented by Reagan Miller, followed by an update by Clay Cole.
Thank you.
Good morning, Mr. Chairman, Commissioners. For the record, I'm Reagan Miller with the Child Care and Early Learning Division. This morning, we're seeking your direction on delaying the reinstatement of TWC's child care attendance policy. In June, you voted to reinstate child care attendance requirements, which would have gone into effect next Monday, July 20th. Subsequent to this action, the governor instructed and HHSC promulgated new emergency rules for child care operations. These new emergency rules are intended to help mitigate the spread of COVID. And one of their requirements is for childcare operations to follow the CDC guidance. This guidance directs childcare providers to limit parent-caregiver interactions by planning for curbside pickup and drop-off and limiting direct contact with parents. Childcare providers have noted that they would like to limit parental access within their facilities to help reduce the transmission of COVID, which complicates our efforts to track attendance using our automated attendance swipe card system, which is located inside a provider's building. Based on these evolving changes, we're seeking your guidance on delaying the reinstatement of TWC's child care attendance policy as outlined in the discussion paper and continuing to monitor HHSC and CDC guidance for child care programs in order to determine when to once again reinstate them. And I'm happy to answer any questions.
Thank you. Comments or questions?
No, I just want to take this opportunity to thank our staff there for the update. So thank you, Reagan and Allison.
None here.
Thank you. Do we have any motions?
I move that we delay reinstating TWC child care attendance policy and continue monitoring the situation as discussed.
Second.
It's been moved and seconded. We're unanimous. Thank you.
Thank you.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, Mr. Cerna. For the record, Clay Cole, UI Division. Just want to start off with a quick UI claims and payment activity update. To date, we've processed over 3.8 million claims and paid out approximately $19 billion in unemployment benefits. Currently, we have approximately 1.7 million active UI claimants receiving benefits. I really commend all our UI staff, contract call centers, volunteers for their commitment, great work for servicing Texas in need. I will say call centers remain open 7 a.m., 7 p.m., 7 days a week. and UI continues to explore options for expanding resources to further improve overall service delivery for customers. Discussions are underway with several potential partners. We're working to identify a turnkey solution. The initial plan is to add approximately 100 contract investigators, 50 appeal junior hearing officers, 30 appeal case processors, and some transcription services for initial 6-month period of time. UI and external relations communications continue to work closely on managing outreach to UI customers. Last Friday, we emailed roughly 1.4 million customers about the Federal Pandemic Unemployment Compensation Program, or the $600 CARES Act benefit that's set to expire week ending July 25th, 2020. So the email communication really, again, making sure customers understand that expiration date that is set on July 25th, 2020. UI and IT continue working on programming for implementing the High Unemployment Period Program that extends potential duration of benefits for eligible claimants up to additional 7 weeks or 30% of their regular UI entitlement. The extension is for individuals who exhaust state extended benefits, or also any of the pandemic unemployment assistance customers that exhausted extends their entitlement from 39 weeks to 46 weeks. And this doesn't change any current Federal CARES Act expiration dates. And this concludes my update, and I'll be happy to answer any questions y'all might have.
Any comments or questions?
No, Chairman.
Chairman, and Commissioner, I'd just like to thank Clay and the team, Ed, again, for the legendary customer service that you guys are providing to employers and those claimants. We continue to get a number of calls, and the staff reacts to those individuals, and we're able to check those off the box. And so just thank you for what you guys are doing.
You're welcome.
Let me echo that and just say I appreciate the continued innovation. You know, we are still hearing concerns from customers intermittently on their ability to do business either with our call centers or our automated systems. And I do appreciate the continued attention to that and the willingness and ability to be innovative and looking for continued solutions to ensure that customers have connectivity with TWC. We do need to keep doing that. I know that you are, and I sincerely appreciate the 3.8 million folks that have completed their claim, the 1.7 that are currently receiving benefits, and the number of other folks that are either contemplating that or trying to understand that better. And I know we've put measures in place all through the system to help deal with the volume of folks that we have, and now the complexity, because at this point, if someone's having issues with their claim or the connectivity with the system, it's probably something more complex than your average run-of-the-mill issue. And I know we've put a number of individuals trying to help people sort those out quickly, particularly when benefits are due. So up and down the system, appreciate the nimbleness, appreciate the innovativeness. I know at this point it's been several months, and we've been running 7 days a week. Unfortunately, we're still running 7 days a week, and we still will be. But I do appreciate the willingness to staff to continue to contribute to the solutions and understand. You know, I don't think our folks have ever lost sort of pride of the fact that these are fellow Texans that we're helping, and I hope we'll continue to find innovative ways to do that as we have been through the process. So to the team, thank you for your ability to continue to solve problems. Unfortunately, there's a couple more problems to solve, and it sounds like you're working on those as well. So I appreciate that very much.
Very welcome, Chairman. I'll let the team know, and I can guarantee a huge emphasis on just making sure that any of those customers that are trying to reach us, that there may be barriers or inability to get to us behind the scenes. We're making sure that we're doing callbacks or emails any way we can to ensure that we're communicating back to those customers. It's a huge emphasis that we're making sure that we're continuing to do everything we can to meet that challenge. And you're right, a lot of work still ahead.
Thank you.
Chairman, I agree with the comments that you made, and probably we've all had an opportunity to visit our call center. Some of us have had the ability, and I mean, we've all made contact with, at some point, with those folks that represent us at the front line, our call center employees. So Clay, I again want to I agree with the commissioner's remarks regarding the hard work that your office and all of your staff is doing, and especially those that are our frontline call center employees. It's nice, and we understand there's challenges, but it's nice to hear from someone that say, hey, so-and-so from Dallas or El Paso answered all my questions. So thank you for the training and working so closely with Tom to disseminate all that information to our constituents around the state. So thank you for that.
You're welcome. Thank you.
Other comments or questions?
No, Chairman.
Thank you very much. Anything else under agenda item 11?
No, sir, that's the last thing we had.
All right, thank you. Tom, do we have a legislative report today?
Yes, Mr. Chairman. Good morning. Chairman Daniel, Commissioner Alvarez, Commissioner Dimerson, and Mr. Cerna. For the record, Tom McCarty, External Relations. The U.S. House Appropriations Committee passed the Labor, Health, and Human Services and Education fiscal year 2021 funding bill yesterday. We did send an email to your office on this, but in summary, the bill includes $196.5 billion in overall funding, which is an increase of $2.4 billion above fiscal year 2020 enacted levels. It also includes $925 million in emergency contingency funding to help states address spikes in unemployment claims, and also a little over $1 billion for registered apprenticeship programs. The bill will go to the full House of Representatives for their consideration. A summary of and as I mentioned earlier, we sent you the summary of the funding levels that went into a little bit more detail to your office. On Thursday at 1 p.m. Eastern, the U.S. House Small Business Subcommittee on Innovation and Workforce Development will hold a hearing titled Putting America Back to Work, the Role of Workforce Development and Small Business Rehiring. We will monitor this hearing closely and provide you a detailed summary as to what transpires with that hearing. We'll continue to monitor congressional actions for potential legislation regarding COVID-19 and any assistance that may be available, especially next week when we expect Congress to be back in session, both the House and the Senate. That concludes my remarks, and I'm happy to answer any questions you may have.
Comments or questions?
Great news, Tom. Thanks for the report.
None here.
Thank you.
Thank you.
Ed, and an executive director's report.
Just one quick item, an item of recognition. The task awarded its 2020 project award for category of application of innovative tools to transform the delivery of public service to our virtual assistant or chatbot, Larry the Bot. So Larry the Bot's been recognized as an outstanding application to transform the delivery of public service. And we're very pleased with the efforts of our staff and our contractor, Accenture and AWS. So
well,
with that, I have nothing else.
I know a lot of work went into that, and quickly we were able to stand up this piece of artificial intelligence in days, not weeks or months. And in fact, in weeks went from version 1 to version 2. I know a lot of people worked very hard, and the recognition for the innovation is very much appreciated.
Yes, sir. It started off with 20 questions, and now we're up to 100 plus gathering information for callbacks and things. So we're very pleased with it.
And I know that's one of the many tools we've used to try to ensure that we can communicate with everyone who's trying to communicate with us. That combined with additional call center capacity and even outbound calls from the information that we can gather from the chatbot and the artificial intelligence. So lots of tools we've deployed in the last, since the middle of March. And I considered it innovative at the time, and I guess somebody agreed with me now that we've
Yes, sir, this is true.
Any comments or questions for Ed while we've got him?
Well, Ed, I want to thank you and the team for, this outside the box thinking and being able to accommodate our constituents regarding the volume of calls. It couldn't have come at a better time when we were celebrating Larry's birthday, which was yesterday, if I'm not mistaken. So it was appropriate for him to receive this award as well. So it was an honor for him to not only have this chat box named after him, but for us to be able to recognize all the great work, not only you, but the staff that were involved in putting this together. And I'd be remiss if I didn't acknowledge it. We had another birthday this past weekend, which was Aaron Demerson, turned 29, I think.
That's right. Thank you, Commissioner Alvarez and Chair. I want to also echo, Ed, thank you guys for the work you're doing. And Chairman, a good idea with the bot that we have that's going forward. I want to make sure that we're marketing that, though. I think you mentioned Accenture as the company or so, but so if we've not done any press about that, I'd love to see that going out so that folks become even more aware of Larry that's out there. So.
Yes, sir. We did when we launched it, but we need to refresh that. So we'll take that. Thank you very much, all of you.
That's fine. The refreshing, but also the award. If that's an award that we received, I'd love to have that going out. If it hadn't, it's probably already gone out. But if it hasn't, an announcement around that award, that's good news for us. All right.
Yeah.
Yes, sir.
Congratulations again, Ed. Great
Yes,
tools
sir.
that we have in place. We have great tools. So thank you for that.
Yes, sir. That's all I had, Mr. Chairman.
All right, thank you. Anything else come before the commission as we celebrate the undisclosed anniversary of Commissioner Demerson's 29th birthday?
I got a lot of cards, let me tell you. So.
A lot of folks wishing you well. I'm glad to hear that.
Yes.
Appreciate that.
Any other order of business? Do we have a motion to adjourn?
Chairman, I move that we adjourn.
I second that motion. All right.
It's been moved and seconded to adjourn, and we are unanimous. This commission meeting is adjourned. Thank you.
See my note up there?
I love it.